Last month, the Supreme Court issued its decision in Pereira versus Sessions, providing a new hope for relief after a final decision of removal. Kanation, here with us today is Attorney Eric Welsh. Let's get down to the facts. Thank you for coming, first of all, to Adobe Nation. Welcome.
Thanks very much.
Let's break it down. What does Pereira versus Sessions mean?
Sure. Well, Pereira v. Sessions dealt with what needs to go into a notice to appear. That's a charging document that puts an alien into a deportation proceeding called a removal proceeding. The question was whether or not a notice to appear that didn't specify the date or the time of the hearing was sufficient. The Supreme Court said it's not. Specifically, the issue in that case was something called the stop time rule. And the question was whether or not a defective notice could trigger the stop time rule. The court said it cannot.
And so you're mentioning the stop time rule. For our Kanation back at home who are listening to this, can you explain to us what the stop time rule is?
So there's a form of relief that someone can apply for in immigration court called cancellation of removal. Basically, they have to show, among other things, that they've lived in this country, in the U.S., for at least 10 years. The stop time rule is a special rule that says that if you're served with a notice to appear before you get to 10 years, that time stops. Prevents a person from applying for cancellation of removal.
Right. And I did hear there was a minimum of at least 5 years. Is that true, or does it have to be 10 years?
10 years, yeah. For cancellation of removal, it has to be 10 years.
Right, I see. With this whole new decision in Pereira, what does it mean for an alien in deportation, or when they're asked to come in for a court hearing?
Sure. Well, if it's somebody who's been put into court with one of these defective notices, so a notice that didn't specify the date, time, and place, then that person at a very minimum would be eligible for cancellation of removal if they've been in the U.S. for 10 years, even if they're served with that notice earlier than 10 years.
Right.
More than that, they might still be able to terminate proceedings, just say, you know what, the court never had jurisdiction because this notice was defective.
Does it matter when they've received this defective NTA?
Doesn't matter when they received it. So there's nothing in the decision from the Supreme Court that would limit it to only cases going forward. So even if this is a notice that was issued many years ago.
Okay. But
there is a rule on a motion to reopen should be filed within 90 days of a change of law. So that's how we calculate that September deadline.
Okay. When a person has received this defective NTA without the time, without the date, without the place, what should they do? What's the first thing that they should do?
Well, they want to file a motion. So in order to do that, it's a good idea to hire a lawyer. So talk to somebody and say, I think I got one of these defective notices. A lawyer can assess the case, decide what the best course of action is going to be. Very likely going to be filing a motion to reopen. Get back into court, apply for relief. There might be something you're eligible for today that you weren't eligible for when you were in court before.
Right. So this is good news for those of us, or for those people who have received these notifications.
Absolutely. Yeah. It's very good news. It's a good decision. It's basically holding the government to a higher burden. They've got to put specific information into a charging document if they want to put someone into deportation court. If they don't do it, that person has a right to proceed to terminate proceedings or to reopen and apply for relief.
And I heard also in the news that the Supreme Court ruling was 8-1, which was very shocking for most. So what do you have to say on that?
Well, I think it's a good sign. It's just showing that the Supreme Court recognizes that there are some things that are just basically needed in order for due process to be ensured.
So taking it from here, the best advice is to go talk to a lawyer?
Well, of course, we want you to come to us, come to my firm. You can visit us at our website at rreeves.com. Give us a call, set up an appointment. We have offices in San Francisco, Pasadena, and in Las Vegas and Manila.
Wow.
So we're happy to help.
Well, definitely, Kanation, we'll give you a call. We'll visit the website. And thank you so much, Attorney Eric Welsh, for visiting us here on Adobe Nation. Always love to have you back.